Good morning and thank you for joining us at DCMS Connect Virtual Speaker Series featuring a legal roundtable. I'm David Strickland. I'm a claims manager at Texas Medical Liability Trust. For the past 23 years, I've been involved in defending physicians in medical professional liability matters. TMLT and the Dallas County Medical Society have worked together for more than 20 years to bring CME, special programming, and risk management guidance to Dallas physicians. TMLT has been an endorsed provider of medical liability insurance since 1994. Today we're focusing on some legal issues that are important to physicians. We have two Dallas lawyers who specialize in representing physicians here with us today, Diane Shaw and Karin Zaner. Can each of you tell us a little bit about your law practices and how you help physicians?
Sure, David. I'll be glad to. And again, thank you. It's just an opportunity to be here. I have worked with medical malpractice defense for close to 40 years in trial defending physicians. In the last 20 years or so, it's evolved into a practice to help with healthcare compliance, regulatory, HIPAA, Texas Medical Board, and various peer review issues that come up. Basically, we're a small boutique firm that has a full service opportunity to help with physicians. Thank you. Karin?
Yes. Hi, I'm Karin Zaner. I practice at Zaner Law, and we have offices in Dallas and in Austin. I've practiced law for almost 30 years. My practice focuses on the professional record and reputation of physicians. So I do peer review, credentialing, and Texas Medical Board work. I also help with employment and other contracts, including things like physician non-competes. My practice is not a full service like Diane's. It's more of a concierge practice where I really focus, again, on the record and reputation of physicians. But whatever your issue is, Diane and I have to be problem solvers. And so please, we hope this will be helpful for you today, and please just call us with any other issues because we will do our best to help you.
Thanks for that. We're glad you're both here. What are we going to be talking about today?
Well, David, some hot topics we thought about, and I did want to mention that Karin brought up the no compete, and I do know that comes up regularly. The topics that we're going to cover first have to do with CMS and audits from third-party managers. Actually, private insurance companies do this as well, but we're focusing on CMS because those are the ones that are more problematic. And many physicians or their practice managers are not aware of the insurance that they have to cover these issues. So the practice managers are working very hard to get the documentation that is necessary. And what they don't know is that there are local coverage determinations, national coverage determinations, and a lot of educational material that's out there that goes beyond the CPT code. And that's what needs to be included. We do have a checklist that I understand will be made available to you that covers everything that we put into packages for each beneficiary for each CPT code. We also, on our checklist, we have some additional issues that we cover, like we will get a CMS consultant to actually go to your office and help maybe even improve or facilitate easier compliance for this in the future.
Thanks, Diane. Karin, do you have anything to add from your experience?
My experience tells me to call Diane. She does a lot of CMS audits, and she knows what she's doing.
So when a physician receives a board complaint, TMLT recommends that they employ an attorney at that time. Why employ an attorney rather than just send the patient's chart along with a letter explaining why the patient's wrong to the board? I mean, why go to the trouble of hiring an attorney?
Diane and I feel the same way about this issue. It's no fun for a physician to receive a TMB complaint from a family member or from a patient, especially given how hard physicians work to take care of their patients. But when your first response to a TMB complaint is due, which is about a month after you receive the notice, that's a really important opportunity. At this point, the complaint is still non-jurisdictional, and so I recommend that a very focused response is submitted. Diane, I think you've called this aggressive.
Yes.
This maximizes your chance of getting it dismissed, which is really important. Diane, your thoughts?
Well, yes, and I do call it aggressive, and I put together aggressive packages, and sometimes the doctor or even other attorneys will say, isn't this overkill? And as a trial attorney, I'm kind of in it to win it, and so I say no, because at this level, if you get a dismissal, you don't have to report it to any of the networks or credentialing privilege boards that are checking in, because they want to know if you've ever been in an investigation. If you can get it dismissed at this level, it is not an investigation, it's an inquiry, and it's not jurisdictional, so it's over. Not all of these complaints are standard of care. Some of them are professional conduct, or some of them are for billing, and those other kinds of sensitive issues that I'm not even going to talk about. But there are many different types. Most of them fall within either unprofessional conduct or compliance with the standard of care issue. But another thing that I'm finding a pattern of at the Texas Medical Board to be aware of is they're using the administrative code, which you'll have a link to, but the administrative code for documentation, and they're trying to say that the standard for documentation is the standard of care. And while documentation has become more and more important, I still say documentation is not the standard of care because it does not treat patients, and standard of care is about patient treatment.
Are there pitfalls that you've seen where you've been able to defend a complaint late after the physician responded to the initial inquiry and the complaint has been elevated to the level of being invited to Austin for a hearing?
Here's the way I approach an initial response to make it focused to maximize the chance of dismissal. So first you have to tell the story of how you cared for the patient. Never trash the patient or the family, even though you might feel like doing that. Make sure the medicine is right. So we've got to make sure and give a narrative that gives a clear, concise explanation in an impartial, not too emotional, but still caring tone. If there are medical and billing records that are not too voluminous, then I like to include those in order to show that there's nothing to hide. Real easy to get those to the medical board so they can see this is it with this patient. If the medical and billing records are really voluminous, then I think there's a decision that needs to be made as to whether to include them or just include the documents that corroborate your narrative with respect to the case. Because at the initial level, it's not required, even though they include the medical and billing records affidavits, it's not actually required to give those at this point.
Yeah, I would agree with that, and I've had situations where a doctor moved practice, and even though they appropriately changed the address and such, the notice of the complaint didn't get to them until like at the time of the deadline or after the deadline, and the board is a real stickler. Once that 30 days has passed, you're going to go into an investigation. So be aware that you must have the correct address on file at the Texas Medical Board so that they can always find you, or a simple complaint may be elevated to an investigation.
Documentation has been brought up a few times. Is there more information that can help doctors understand the importance of documentation and HIPAA?
Yes, and let me start with a question for Diane. Diane, have you ever had a physician who you have never talked with send you protected health information, we call that PHI, to you?
Yes, and Karin, I know we've discussed this, and I think we will agree that doctors are increasingly aware of HIPAA and details like the business associate agreement, which we call a BAA, often secure links, encryption and such, but there are physicians who are not.
Diane, I totally agree. And in my previous question to you, I think the answer is physicians don't send protected health information of any patient to anyone unsolicited, even if it's an attorney. Talk to them about the fact that you have the information, but talk to them about how do I need to get it to you. And that's really important. So I think going over some basics of HIPAA doesn't hurt at this point. And let me just ask David a question. David, do you know what protected health information under HIPAA actually is?
It's patient information like name, address, birth date, social security number, medical record number, patient information that's supposed to be kept confidential by the physician, right?
Absolutely. PHI is not just that. The definition of PHI includes all individually identifiable health information held or transmitted by a covered entity in any form, so oral, paper, electronic. If it identifies the patient or can be used by a third party to reasonably identify the patient, then it's PHI. So even if a physician would redact the name or other specific information, there can still be PHI in the information that's being sent. So, and then what that would mean is that sending it to anyone, even a lawyer, may be a HIPAA violation unless the sending is done right. So let me give you an example. Say a physician sends an email describing care that resulted in a young patient's death at a particular community hospital. That physician may have redacted the information you mentioned, name, birth date, social security number, address, but just describing even these general facts, that it's a young patient, the patient died at a certain small community hospital, may allow for a third party to identify the patient, maybe from the local news or from community gossip. And so those details can in fact be PHI. This gives us reason and gives every physician reason to be very careful with the information related to patient and treat any of that information, including details of patient care, as PHI. And be careful with it.
So Karin, what do you mean by be careful?
What I mean is that every practicing physician should really assume that he or she is a covered entity. There's a very legal definition of covered entity, but unless you have legal advice to the contrary, that for some reason, whatever you're doing, you're not a covered entity, then I think you've got to assume that you are, and that means you have to comply with HIPAA. Complying with HIPAA means lots of things. HIPAA is a very complicated, lengthy law, but specifically, physicians, please remember, don't send any PHI, any information about patients, to strangers. And don't even send that to lawyers unless you talk to them first. First, you want to talk to the lawyer about it before you send. An important thing to remember is if it's not necessary for their representation of you, then don't send it to them. If it is necessary for your representation, then the lawyer should know that a business associate agreement is required. That lawyer is a business associate and can receive information. So the lawyer should be able to provide you with a business associate's agreement and tell you how that PHI under that business associate agreement needs to be treated, guide you for that. Once the BAA is signed, then the lawyer can direct you as to how to send the particular PHI in a HIPAA compliant way. And that might be encrypted email, private fax, tracked mail, hand delivery, but that lawyer should help you know that. Now, if the lawyer says, what is a BAA, then guess what? Time to find another lawyer. But healthcare lawyers, and in particular lawyers that represent physicians regularly, should know exactly what they need to do to help you and protect you. The other thing I'll say is that watch out for emails like yahoo.com, hotmail.com, other emails that you don't have to pay for, because typically those are going to be non-compliant with HIPAA, and so you really have to be careful what you say in those emails. And if anything, you want to attach any protected health information as an attachment that's encrypted to that email. But again, that lawyer should help you.
Under the HIPAA compliance laws, you're supposed to have a list, of vendors who can come into your office, clean, get blood, whatever they might be doing. And every one of those vendors that might be able to access your computers or your files in some way is supposed to be signing a HIPAA compliant business associate agreement.
But it's important, again, to have an attorney help guide you through this because it's a difficult, complicated law.
Yeah.
Well, actually, there's one more thing. I really like this sheet as it relates to mobile devices in HIPAA. And so this is a sheet that the Health and Human Services, the federal government, provides. This one-page sheet really has best practices when it comes to mobile devices, really important. I like to have this handy, and this will be in the materials that you'll have access to. It recommends that all physicians and all covered entities should strictly observe certain protocols for any mobile devices that contain PHI. including, for example, and this is the most important one, maintaining physical control at all times of the device. It's really, really important. You pair that with using encryption and passwords to make sure that nobody else, even if for some reason they find your phone on the Starbucks table, which shouldn't happen, right? But even if it's lost, that they can't get into it with encryption and with passwords. Very, very important. Also important is to install firewall and remote disabling software. Again, in case you lose it, you're able to remotely disable that, and that's very important. Using adequate security when using public Wi-Fi networks, very, very important. And in fact, I will go even, I think, with better advice of not even using public Wi-Fi on devices that have protected health information on them, because there's fraudsters out there, and they can get that if you're doing that with certain devices. And the last one would be deleting all PHI before discarding any device. So if you're giving away your old laptop to your college student son, or to Goodwill, or to for charity, making sure, or if you're destroying it, right, making sure that it's destroyed in the right way, and making sure that if you're giving it away, it's actually wiped.
Again, great information. Shall we move on to the final topic of the day?
Yes, David. Thank you. And our next topic is telemedicine in Texas, which now seems to be everywhere given the pandemic.
So David, let me ask you this. What if I told you could make some extra money doing telemedicine at home as an independent contractor? What if I told you that you could connect with a company that would provide an online portal so that you could access and do patient consults, and I told you that the company would credential and train you from the comfort of your own home? In fact, you could do the work from the comfort of your own home, or anywhere you have online access. What if I told you that you wouldn't even have to see patients or talk to patients? What if I told you that you could get paid $25 per consult, $50 per consult, even $100, and you could do hundreds and hundreds of these consults and make extra money? Would that sound good to you?
Sounds like a good deal to me.
Well, David, let me tell you, don't fall for it. There are fraudulent telehealth companies all over for years now, luring physicians, especially if the physician has multi-state licenses, into these types of schemes. So there's various red flags that you really need to be aware of. They're typically independent contractor relationships as opposed to employment, although not all the time. The next is an online portal that keeps all the medical records by the company in their online portal. All the billing happens by these companies, so in other words, the physician has no control over these functions. Once the portal is gone, the physician has nothing. The physician does not see or talk to patients, so the question becomes, how does that physician establish a patient-physician relationship with that patient and appropriately prescribe or give care to that patient? These companies are unfamiliar. They may be new. They may be all over the state, and they may be all over the nation. They may be connected to locum tenens company. Even reputable ones are ones that can connect a physician with this. The payment, $25 to $100 per consult, although it could be more. But that low payment tells you that it's probably something where you're probably doing a lot of these, and you're making money in a way that it does not comply with the telemedicine laws. When you're credentialing, what happens is that the companies will get your NPI number, they'll get your e-signature, and then they can place, they can ask you to place that on various patients, their records through the online portal, but they can also use those NPI numbers and e-signatures and place them on files you haven't even seen. There's an operation by the Department of Justice called Operation Brace Yourself, and this was a bust of a scheme in 2019 where Medicare beneficiaries were duped into signing up for unnecessary genetic tests, durable medical equipment, prescriptions, and those companies needed physicians and their NPI numbers and their signatures in order to get these prescriptions. These have resulted in indictments, and similar schemes are still happening, and the newest one is called Operation Happy Clicker. And that's something to be aware of. They're happening, and again, these companies lure physicians into this, so don't fall for it. Even if you're not indicted or called to be a witness, your participation in these schemes can be detected by insurance providers and who can do something to your privileges or provider status, and they certainly can report you to the state medical boards. And with that report, the board is looking into it, especially here in Texas, and that can result in a lot of problems for physicians. So it's very dangerous. The bottom line is that you really have to get legal help before you sign up for anything like this. Don't trust too much, as there really are fraudsters out there who want your NPI number, who want your e-signature. You at all times have to be very protective of your record, your reputation at all times, which includes not getting involved in these types of schemes.
So how can a physician do telemedicine right? Seems to be everywhere today.
Lots of folks, employers, hospitals, physicians are doing telemedicine right.
Each individual physician must understand what the law requires. And in Texas, that means the telemedicine statute, which is Chapter 111 of the Texas Occupation Code. And so it's really important for physicians to really be able to understand what that statute allows and how to practice telemedicine right.
So where can a physician practice telemedicine?
That's a really good question. So let me explain that, because it's really important for physicians to understand how this works. So the practice of medicine, including treating or prescribing through online service sites, the practice of telemedicine occurs at the site where the patient is located at the time the telemedicine technologies are used. A physician must possess the appropriate license where the patients receive care. So the law of the state where the patient is located must be consulted to determine whether a license in that state is required. So for Texas physicians, in Texas, a physician licensed in Texas may practice telemedicine within Texas, meaning patients located in Texas. Texas also allows out-of-state physicians to provide what's called episodic consultations in Texas without a Texas medical license. But that physician must register and pay a fee required for such license, again, an out-of-state license to practice medicine, telemedicine in Texas to Texas patients, got to pay for that license through the Texas Medical Board. Now, Texas physicians desiring to practice telemedicine in other states, so patients in, for example, Georgia, they must assume that specific state-to-state licensure is required in whatever state the patient may be, Georgia or Florida or Arkansas. Unless you get specific legal advice otherwise, then I think Texas physicians really do need to assume that state-to-state specific license is required for that physician to practice that telemedicine from Texas, where the physician is located, to a patient in another state. Now, a physician may opt to get multiple licenses in various states. So you could be a Texas physician and have licenses in Georgia, Florida, and all the other states. That tends to be kind of cumbersome and expensive. And the physician also has to be aware in each of those states where he or she is licensed of all the requirements in those states for practicing medicine, including telemedicine. We now have something called the Interstate Medical Licensure Compact. And that is a streamlined procedure that helps physicians license in more than one state. Texas now participates in that through House Bill 1616, which was a recent development. And so Texas is now accepting applications. Eligible physicians can complete one application and receive separate licenses from each state so that they can practice in each state.
Again, great information. I really enjoyed our discussion today. Thank you both for participating.
Well, thank you, David. I really appreciate being here. I appreciate Dallas County Medical Society. It's been a privilege and an honor to do anything we can to help. And Karin, thank you. It was great input.
Thanks, Diane. David, it was great. I really enjoyed myself. And remember, we're here to help, so please call us. Our contact information should be given in our materials that we referred to, so we're here to help. So thanks for having us, and take care.
Thank you all for joining us today. We hope you learned something new. More great legal health care information is available in the April issue of the Dallas Medical Journal, available now online at dallas-cms.org. We hope you'll join us for another DCMS Connect virtual event this July, featuring a legislative update and preview for the 2023 session. Thank you.